Hi guys, welcome back to my channel. So today in this video I would like to continue the previous video entitled The Maritime Executive Carriage of Goods by Sea. The bill of lading and the terms of the contract of carriage. The terms of the contract on which the goods are carried are prima facie to be ascertained from the bill of lading. As between the ship owner and an indoors, the bill of lading constitutes the contract, and it may also constitute the contract as between the ship owner and the shipper. Although the contract of carriage will generally be made before the goods are sent to the ship, the contract may afterwards be reduced into writing and expressed in the bill of lading. Apart from bill of lading, goods can also be shipped by other contracts, for example, contract of affreightment or charter party. International carriage of goods by sea and contract of carriage are governed to a large extent by international convention. To a large extent, carriage of goods by sea are governed by the International Convention relating the carriage of goods by sea and similar laws enacted in the countries of shipment. The legislation governing carriage of goods at sea sometimes depend on the types of contract that are used in the carriage. Where the seller of the goods sell in large quantities, it may charter the whole or part of the ship. The charter of a ship is the hire of the ship for the use of the charter. The three main types of the charter are bareboat demi charter, time charter, voyage charter, bareboat demi charter. Under a bareboat or demi charter, the vessel is chartered in pair from the use of the charterer for a period of time. The charterer is obligated to supply wherever is needed for the operations of the vessel, including the crew. It has been explained in the Singapore High Court decisions of Pan United Shipping Pta Limited v. Cendrawasih Shipping Pta that whether a ship has been demised depends upon whether or not the ship owner has been parted with the whole possessions and control of the ship, and to this extent that he has given to the charterer a power and right independent of him and without reference to him to do what he pleases with regard to the captain, the crew, and the management and employment of the ship. A common industry from a charter is the bargain form of charter. Time charter. Time charter deploys the vessel from the executive use of the charter for a fixed period of time. The master is obligated to sail the vessel under the instruction of the charterer. The charterer is obligated to indemnify the master and owner for the consequences of obeying the instruction of the charterer. Under a time charter party, the remuneration payable to the ship owner is called hire. The time charter is most suitable for cases where the use of the vessel is definite for the contemplated period. An example, Petronas charter of ISC vessels. The common form used include time, shell time. Voyage charter. Under a voyage charter, the vessel is chartered for specified voyages. The voyages can run consecutively for back-to-back deployment of the vessel. The voyage charter is the most common form of charter. Some common forms of charter include Asbatan Kivoy, ExxonMobil, Voy, Zelvoy. This vessel owner is keen for the voyages to be completed as soon as possible to free the vessel for further deployment or additional charter. As such, the voyage charter will often have fixed lie time and demurrage provision to provide a financial incentive to the charterer to complete loading and discharging as soon as possible. Demurrage disputes are the most common form of dispute in voyage charter. Furthermore, the vessel owner will often shift the risk of delay under the charter provision to the charterer. Under a voyage charter party, the remuneration payable by the voyage charterer for sea carriage of goods by sea is called freight. Chartering process. Parties can negotiate directly, especially if previously dealt with each other. Often the vessels are sourced by shipbrokers, and the shipbrokers act as intermediary the negotiation and finalization of the charter party terms. Often the charter terms refer to the standard or industry forms. Even if the forms are commonly used, it is important to do the following. Understanding the term, realize the feature of recap, conclude the contract. The signed detailed charter party is the formality. Sailing of or deployment of the vessel is already the performance of the charter. Standard forms are adapted to transaction by use of reader clauses. As a general rule, reader clauses will override the standard form wording where inconsistent. Certain terms will be implied into the charter where necessary to give business efficiency to the contract, as what the parties must have intended, or to impose implied obligation of the vessel owner. An example that the vessel must be seaworthy. Apart from the contractual relationship and the express and implied contractual duties, there are also obligations and responsibilities imposed by law. An example that is under bailment, lien, maritime law, age, general average, salvage. Bailment. A bailment, traditionally defined, is a delivery of personal chattel on trust, usually on a contract, express or imply that the trust shall be duly executed and the chattel to deliver in either their original or unaltered form as soon as the time or use for or condition on which they were bailed shall have elapsed or been performed. Under modern law, a bailment arises whenever one person is voluntarily in possession of goods belonging to another person. The legal relationship of bailor and bailee can exist independently of any contract, and is created by voluntary taking into custody of goods which are property of another, as in cases of sub-bailment or of bailment by finding. The element common to all types of bailment is the imposition of an obligation, because the taking of possessions in these circumstances involve an assumption of responsibility for the safekeeping of the goods. An action against a bailee can be regarded as an action on its own, sui generis, raising out the possession had by bailee of the goods. Carriers are bailees of the goods carried. In the Privy Council case of the K.H. Enterprise v. Pioneer Container, the Privy Council held that on receipt on the good on board the vessel, the carrier becomes bailee of them, owing a duty of care to the owner of goods. The bailment is founded on the consent of bailor and bailee, and the bailee's voluntary taking into possession to property of another, which creates the bailment relationship. So this is the end of the article. Don't forget to watch my previous video, and bye bye.